folks, and welcome back to Contract Law. This is part 3 in the video series on the Australian consumer law, and in part 1 we had a little look at the Competition and Consumer Act and the ACL, which is housed within the CCA. We're talking in acronyms, as Schedule 2, and we saw all about how it operated. In part 2 we had a look at the consumer guarantees, which is a nice little set of terms that you can rely on, guarantees, funny about that you can rely on when you are dealing with suppliers of goods and services if your contract happens to fall within that regime. And now we complete our little foray into the Australian consumer law by looking at unfair contracts. Well, I guess the phrase unfair contracts is kind of a misnomer. Really what this regime is all about is picking out of certain forms of contract, consumer contracts, unfair terms. Whether or not those contracts stand or fall without the unfair terms is a matter that would have to be decided at the end of the day once they have been declared unfair terms. We'll look at that when we get to remedies. But the unfair contracts regime was a fair time in the making. Like with many of these kinds of regimes, often something that will be talked about forever and ever and ever, and there's endless talk fests that go on. There was some movement in the United Kingdom to implement a regime that dealt with unfair terms in consumer contracts prior to us, and we had a good look at that when we were drafting up our legislation. But everyone was very keen to get the unfair terms provisions into federal legislation as quickly as it could possibly be. There was a lot of talking up of this regime when it was being rolled out and when it was being drafted. And a lot of people, I think, saw this as a bit of a saviour, if you will, of the common person and in their ordinary dealings with big business, if you will. Because it was pitched at that angle, there was a little bit of concern. There was concern by business in terms of what this regime would do to its ability to contract with the little guy, and whether and how, to what extent, the terms in their usual contracts would be considered unfair. And there was kind of this great uncertainty about whether or not this regime was going to be really, really hurtful of business and the freedom with which businesses could operate. And so even though there were some noises when this legislation was being drafted about including small business as a beneficiary of this regime as well as consumers, wow, big business really just leaped up and down and really made a song and dance about it. And so the whole issue was kind of put on the back burner until fairly recently. So the unfair terms provisions in the legislation were rolled out in 2010, but the unfair terms provisions, so far as they benefit small business, really only commenced in 2016. So this set of terms, as far as it has been applicable to consumers, has been on the books since 2010. Even though the Competition and Consumer Act was rolled out on 1 January 2011 and drafting was well advanced by then, the unfair terms regime was brought in 6 months earlier because everyone just wanted to hurry up and get it on the books. Everyone thought it was going to be just the next best thing since sliced bread. Well, except big business, that is. And as I said, the unfair terms provisions, so far as the small business goes, was introduced in 2016. So we need to first have a little look at the various different terms and the hurdles that you need to get over I'm not really going to go into the small business provisions so much in this video series, because it kind of falls outside of the purview of our focus for present purposes on the consumer. So we'll be having a look at what forms the basis of consumer contracts, although you should have some inkling about that already. We'll look at the notion of standard forms. We'll look at what exactly is an unfair term and the remedies. Then if you need to know how this regime was rolled over and applied in terms of the small business, you can have a look at the text for more information there. So looking first at the issue of contracts. So the contracts to which the consumer arm of the unfair contract terms regime applies are the ones that we had a little look at in part 2 of this video series, although with one slight tweak in the drafting. And it seems to introduce quite an interesting difference. If you look at the definition of consumer contracts in section 23 sub 1, we see that you have to have a supply of goods or services or the sale or grant of an interest in land to an individual, no real surprises there, whose acquisition was wholly or predominantly for personal, domestic or household use or consumption. So you've got to buy goods or services wholly or predominantly for personal, domestic or household use or consumption. Now, that phrase might seem quite similar to the one that we looked at in video 2, but in video 2 the definition of consumer says, or acquisition as a consumer, says that it's got to be either 40,000 or a vehicle or trailer to be used for carting goods on public roads, or of a kind where the acquisition involved goods or services ordinarily acquired for personal, domestic or household use or consumption. So here we seem to have the usual definition of consumer acquisition being measured by whether or not that kind of good was the kind of one that most people would buy for household use, private, personal, domestic household use. But in section 23, we have a provision that says if you buy these goods or services and the acquisition was wholly or predominantly for personal, domestic or household use. And it seems to introduce a measuring stick that is subjective. Interesting point, and one that you may wish to go and have a look at the text for and explore a little bit further, because subjective tests don't come around very often, but this certainly seems to be one example of same. Then we have the notion of small business contracts, and as I said, I'll leave you to explore that. No real magic there, but the threshold contracts value is generally speaking a bit higher. In order to fit within the regime, your contract also has to be a standard form contract. A standard form contract. These are sometimes called boilerplate contracts or template contracts. They are simply the kind of contract that a often big business uses to deal with the little guy, with consumers. From the business point of view, standard form contracts are a real godsend because they save a whole lot of time, money and effort that would otherwise have to be sunk into drafting a fresh contract for every consumer that they serve. So standard form contracting is, at last estimate, about 99% of the contracts that consumers enter into would be considered to be a standard form contract. However, human nature being what it is, there's always the temptation on the part of the big guy to slip in a term that's rather uncomfortable or rather naughty in terms of the little guy's best interests. So these are the kinds of contract that are squarely at issue for the unfair terms regime. In order to constitute a standard form contract for the purposes of the ACL, you need to have a look at section 27. And interestingly, because the regime is designed to benefit consumers first and foremost, we have this handy-dandy little presumption. All the consumer really has to do is say, no, hang on a minute, I'm a consumer, I've acquired these goods as a consumer, look at section 23, I satisfy the definition there, and this is a standard form contract. And the court basically takes it from there. Once they say, hang on a minute, this is a standard form contract, it will be presumed to be a standard form contract unless there's some kind of evidence that shows otherwise. So when you think about standard form contracts, I mean, you doubtless entered many standard form contracts in your consumer career to date, anything from mobile phone purchase, phone services provision, finance for a car, purchase of a car itself, purchase of a home if you're lucky enough to do that, lease, so renting premises as well. All of these things are likely to be standard form contracts, and from your experience you'll know that the stuff that the legislation sets out in section 27 sub 2 as kind of the hallmarks of the average standard form contract, you will have seen in the standard form contracts that you have entered into. So in determining whether or not a contract is a standard form contract, the court has to take into account, may take into account, such matters as it thinks relevant, but it must take into account the following. Okay, and as I said, these are just typical kinds of hallmarks of the average standard form contract. One party, sorry, that should say one party has all or substantially all of the bargaining power. Hello, me versus Telstra. Yes, usually the other party will have the bargaining power. It'll be prepared before any discussions have happened in relation to that deal. Yes, that's usually the case. Also, where one party is required to either accept or reject the terms, there's no real opportunity to engage in negotiations. Another typical hallmark of the standard form contract. Again, something similar. One party is not really given an effective opportunity to negotiate the terms. Then we have really the only one that I think that's kind of interesting, and that is the courts must consider whether the terms take into account the specific characteristics of another party or the particular transaction. So the query is there, and the text kind of goes into this a bit. Does it mean that as a big business provider of goods or services that you can get out of this regime simply by providing enough opportunities in the meets and bounds of the four corners of your standard form contract to take the other party's circumstances into account? That's a question that hasn't really squarely been answered yet. But this is the requirement of standard form. It's not going to be too problematic for the average consumer because obviously they have the benefit of that presumption in section 27 sub 1. The next question, and I guess the meatiest question, is whether or not the term that the consumer doesn't like is an unfair term. So for this we need to have a little look at a couple of different provisions in the legislation. Firstly, there are some terms that are just kind of excluded from the operation of the unfair terms regime, and they are set out in section 26. Fairly sensible, all of them, if you think about it. So terms that describe the main subject matter of the contract. I want to buy a 2019 model Toyota Tarago. I don't know if they make those, in blue, for example. That's not going to be unfair. It's just the thing that we're bargaining about. Upfront price, so terms that set out the actual price of whatever it is that you're buying, the good or service. And also excluded terms are those that are required or permitted by law. So if something is in the contract because of certain legislation, then you can't complain about that term as an unfair term. And I think the text gives you a nice little example of the one-day cooling off period in relation to the purchase of I think it's second-hand motor vehicles that's in all of the standard form contracts that deal with sale and purchase of those kinds of motor vehicle. It's in there because of motor vehicles legislation, and you couldn't, for example, complain that that one-day cooling off period was too short and therefore unfair and try and bring it within the unfair terms regime. Okay, so all of those exclusions are fairly sensible under Section 26. But the real meat of what we need to look at is contained in Section 24. And a term is going to be unfair, and here are your three major hurdles. Really only the first one poses an issue. So the first one is it's going to cause a significant imbalance in the parties' rights and obligations, a significant imbalance in the parties' rights and obligations. There was some uncertainty to start with how significant the phrase significant imbalance was going to be. Did it just mean that it was an imbalance and, you know, it was not minor, it was just of some importance, it is of some consequence? If that's the way the phrase significant imbalance was interpreted, you can see that it would tend to sweep in a lot more terms into this unfair terms regime, because almost all standard form contracts will have some form of imbalance drafted in there, necessarily because you've got, you know, big business dealing with the little guy. But what the regime is really directed at is fairly, you know, important imbalances that it needs to correct. And so whilst we had this uncertainty, there was an early case that tended to suggest that it didn't have to mean significant in the sense of substantial. However, in the Jetstar Airways and Free case, we had Mr. Justice Kavanagh doubting the earlier case, in fact saying that he disagreed with it, and he thought that significant imbalance has a meaning not too distant from substantial. Justice Kavanagh's comments were taken up in the later case of the ACCC and J.J. Richards and Sons, and in that case they had a look at a couple of different cases that would provide guidance on the phrase significant imbalance. And they said that the requirement is met if it's so weighted in favour of the supplier as to tilt the parties' rights and obligations under the contract significantly in its favour. This may be by granting to the supplier of a beneficial option or discretional power, or imposing on the consumer of a disadvantageous burden or risk or duty. And then they quote directly from Kavanagh in saying significant in this context means significant in magnitude or significantly large to be important, being a meaning not too distant from substantial. So we can see the courts have been milling about in the early days of this legislation to try and find meaning to this, to the phrase, impute some meaning to the phrase, and we seem to have settled on the fact that we need to have a fairly substantial imbalance in the parties' rights and obligations. Okay, so if the consumer can show that the term is unfair in terms of the way it would affect the balance of the parties' rights, what are the other two things that the court needs to consider? Second one is that the term is not reasonably necessary in order to protect the advantaged parties' legitimate interest. Again, the reason why I say these aren't too problematic for the consumer is a presumption applies here to help the consumer along in showing that these criteria are satisfied. So this presumption reverses the onus of proof, and the person that's seeking to rely on the so-called unfair term, the advantaged party, will need to lead evidence that in fact the term was required to protect its interests. So it will need to show some legitimate interests at play as the reason why this term was drafted in, and then it will need to be shown that the term is reasonably necessary to protect the legitimate interest that they have just pointed to. And if you have a little look at the text, it says the courts are probably going to be unwilling to find a term reasonably necessary to protect legitimate interests unless the term is proportionate to the potential risk and the interest sufficiently outweighs the detriment to the consumer. And what are some of the things that may be a legitimate interest? Well, obviously, you have an interest, for example, if you have a default term in your contract, you may wish to impose some default interest. In legislation that's not too dissimilar from this legislation, the Contracts Review Act, we've had a decision there saying, well, even if you need to impose a default interest provision, 75% worth of default interest is not reasonable in protecting the legitimate interests that underpin that kind of provision. So again, the text is scouting around looking at decisions from comparable legislation in order to try and show us the way that this provision might be interpreted, because even though the legislation was adopted in 2010, that's really not a terribly long time in terms of either legislation or contract law, is it? When we look in contract law at decisions from 1603, the Rule in Pinnell's case, don't we? So we haven't had a whole lot of case law in this area just yet. The final criterion that the court must consider in determining whether the term is unfair is whether the term will cause detriment, and that's fairly self-explanatory. Usually not too hard for the complaining consumer to show. Overall, that's not the end of the exercise. The court also has to look at or bear two things in mind. While they are looking at the above three criteria, which they must all consider. Okay, so all of those three criteria must be considered. You have to look at the extent to which the term is transparent. And here we have a particular stick that's been adopted by the legislation to make big business in their standard form contracts adopt plain English language. If you don't nowadays, you're just running the risk of running foul of this legislation. What transparency means is that the contract has to be drafted in anything but legalese. It has to be easy for the consumer to read. The placement of the terms is also going to be important. The other thing, obviously, and we've been looking at this throughout the contract law unit, is that the term has to be interpreted in its natural environment, in the context of the contract as a whole. So you can't just pick out one term and just look at it in isolation. You have to look at it as it's bedded down with all the other terms. And if bearing the transparency and the contract as a whole in mind, when the court comes to consider those three criterion, significant imbalance, reasonably necessary to protect legitimate interests and detriment, if it seems to the court that the term is unfair, then happy times for the consumer, because the remedies become available. To give the court a little bit of a helping hand in trying to work out whether a term is going to be unfair, we have come up with this, what is lovingly called by commentators the grey list, the grey list of terms. And that's what we're going to look at right now. So why is the grey list grey? Well, the terms on the grey list are not black, that is, they're not prohibited, and they're not white. So they're not expressly permitted. They're kind of somewhere in that uncomfortable grey limbo land. So if you were a big business trader looking to draft up a set of standard terms and conditions, then you would want to think long and hard about including any of these. And if you did include any of these, you would want to make sure that you had a look at the legislation and had already thought about how a court would come down if they had to look at the term, whether they would think it was unfair or not. Generally, the list is, obviously, because it's just grey and it's non-exhaustive, it's just to give courts a flavour, if you will, of the things that might be considered unfair. Generally speaking, terms that might cause problems are things that involve significant asymmetry. Remember, we were just discussing significant imbalance. That's the kind of thing that the courts are really looking hard at when they're applying this kind of legislation. So they're looking for significant asymmetry in the parties' rights. And this grey list contains a number of terms which show the typical asymmetry in party rights that will be apparent from the face of a standard form contract. Things like asymmetry in the ability of one party to avoid, for example, liability under the contract. So things like exclusion clauses are a big thing there that the courts will look very carefully at. Where there's asymmetry in termination rights. So one party can unilaterally terminate whenever they want to. That may attract some attention. Where there is asymmetry in penalties that are applied by the contract. Where one party has the ability to unilaterally vary the terms or vary the price. Banks are notorious for this stuff, and mobile phone companies. If a company does want to include things like a unilateral right to vary terms or vary price, they have to do it in a very, very careful manner, and it will usually require some balancing right on the part of the consumer. For example, if they have the unilateral right to vary terms or vary price, then you would normally expect to see some balancing right of, for example, termination. So have a look at section 25 of the legislation there. In terms of remedies, this is where I guess it kind of gets interesting, because remember I said to you at the beginning, everyone was kind of looking with great anticipation at the introduction of this unfair terms regime and exactly what it would do for the consumer in terms of standard form contracts. However, when you really look at the remedies that are available, well, you might consider this a bit of a toothless tiger, really. The first thing that you need to do if you believe that a term is unfair, a consumer believes a term is unfair, is seek a declaration from the court under section 250 that the term is in fact unfair. Now, if you have the declaration made, happy times, because the term will be void and unenforceable against you, obviously, under section 23. If the contract can survive without that void term, then obviously the contract's just going to keep chugging along and you'll be bound as before. So it certainly doesn't give you any right to terminate the whole contract here. It just gives you a right to ask the court to hold the provision void. If the contract can't survive without the void term, then the whole thing is actually going to fall over and the contract will just end. The other interesting thing, I guess, where does that leave the consumer? It leaves the consumer with a good argument, I guess, against the big business that's attempted to impose this term, that they just can't enforce that term against them. Well, that's great, although you've had to go to a lot of cost and expense in order to try and prove that a term is unfair and therefore not have it enforced against you. I'd hazard a guess that most people just wouldn't bother. And the other thing is, okay, you've got the provision declared void. You actually can't get anything back from the big business person that is imposing this term on you in terms of real compensation unless they continue to apply or rely on the term after it's been declared void. So you have to go to court to get the term declared unfair and void, and then you have to wait if your contract's still chugging along. You have to keep performing your contract, and then only if the person advantaged by the term continues to apply it against you or seek to apply it against you is when you can then turn around and seek some kind of remedy under Section 237 sub 1 sub 2, or you can seek an injunction against the person applying that term against you under Sections 232 1 and 3. So, not sure whether it's really, at the end of the day, as valuable as we thought it was going to be. I guess the big take-home message out of all of this is that there is the possibility of regulator action here. Even though including unfair terms is not technically a breach of the Competition and Consumer Act, and so consequently, you're not going to be imposed any penalties for doing so. Under Section 250, the regulator can go ahead and seek a declaration that the term is unfair and therefore void. So I guess the regulator is the person, the entity, that would have the most deep pockets and the best interest in terms of wider enforcement of this legislation in order to take action against big business in what they're doing in their standard form contracts. And that's precisely what you see this legislation starting to be used for. So the regulators can step in and interfere, so to speak, in a good way to try and stop these unfair terms. However, like I said, there's no penalty that's imposed here. All we really have is the possibility of the court declaring a term void. And I think even the ACCC is fairly frustrated about this. The best thing that they've been able to recommend is that if in fact a term has been declared unfair and void and the big business person is still trying to go ahead and enforce that term, then they may be making a misrepresentation under Section 29 sub 1 sub M of the ACL, and you may be able to get remedies against them that way. So there is a bit of a backdoor there, I guess. You can try to get them for misleading or deceptive conduct under Section 29 1M. But at the end of the day, I'll leave you to read up on this regime, and that brings us to the end of our little discussion on the Australian consumer law. And as I said before, there are two other areas of the ACL that are of interest to us in contract law, both unconscionable conduct and misleading or deceptive conduct, which we just mentioned a second ago. But we'll leave those two topics to another video series. So thanks for watching, and until I see you in a Zoom or chat with you by email, or you can tweet me, or you can send me a message on Facebook. Bye for now.